Hearing in the appeal, Iceland Foods Limited against Berry.
Yes, Mr. Kalinsky.
Good morning.
Good morning to you.
Rules and Ladyship. I appear in this matter with Mr. Luke Wilcox on behalf of the appellant Iceland Foods Limited, my learned friend Mr. Timothy Mooreshead of the Queen's Counsel, and Mr. Zach Simons appear on behalf of the respondent valuation officer. The issue concerns the approach to and meaning of the phrase trade processes as it appears in Class 2 of the Valuation for Rating Plant and Machinery England regulations. The particular point of controversy in the litigation is whether the air handling system at Iceland's Speak store in Liverpool, which on the findings of fact of the upper tribunal mainly serves its integral refrigeration cabinets, whether that is used as part of a trade process. Iceland say it is because trade processes should be understood as a broad concept referring to and informed by the particular activities of the tenant on the premises, and or because the use of the cabinets to keep produce frozen and in a frozen and refrigerated state is part of a trade process on the ordinary meaning of the words. And we say, in short, that the court below erred in approaching the proviso to Class 2 as a narrow exception to a general rule, in treating transition from one state or condition to another as the essence of the phrase trade processes, and in characterising, or as we say, mischaracterising, Iceland's activity as the display of goods for retail sale, and therefore as the antithesis of a trade process. In its case to this court, the respondent valuation officer goes further than the courts below did and advances a positive thesis that the purpose of the proviso in Class 2 is to create a narrow exemption to benefit certain productive activities of industry. That's the way it's put in, for example, paragraph 122 of the respondent valuation officer's case. Now, we say that that thesis is mistaken, and in any event, it is also a significant departure from how the proviso has been understood and applied in practice over a great many years.
Your case is that a retail trade is no worse than a manufacturing trade, and no reason for rating purposes to treat them differently.
Well, that's essentially right, and I say that broader approach to the ordinary language of trade processes as it appears in the legislation is when we actually examine that legislation and think about its functional purpose. It's actually consistent, and it serves the scheme far better than the restrictive approach that isn't a requirement on the language and actually defeats rather than serves the function of the proviso. So, my lord, that's essentially the answer. I hope to develop that. The subject to your lordship's preferences to the contrary, your lordship and ladyship's preferences to the contrary, the brief structure, I'm going to deal with the facts incredibly briefly, but I do need to take one or two references to set the context and also to deal with a couple of points in the respondent's case. Then want to show, again, incredibly quickly, the shape of the arguments in the proceedings below, just to show how we got to this point in time. Then the real focus of the submissions will be to look carefully at the structure of the 2000 regulations and to understand the role of the proviso, and then to take the court through an express journey through quite a lot of material, but effectively in chronological order, looking at what the key material that actually assists on understanding the role of this proviso is from prior to its first enactment in legislation to the current time.
Good. Well, keep in mind that we've read your very full one-title rows in your opening paragraph when you said it was a short point, but it's a short point that obviously required a fair amount of dilation, and I think it's received that in your written printed case, and we have all read that, and of course the respondent's printed case, and we're very familiar with the factual history, which is recounted in the upper tribunal's decision and quoted extensively in the judgment of the Chancellor.
My Lord, understand I will take the materials as read when they're sufficiently
Yeah.
referred to in the case and
Right.
just point where we are, so which will allow me to take the matters certain matters very quickly and just to spend the time on the ones that are really capable of being illuminated in the oral discussion. But may I just very briefly, with those observations in mind, start with the facts, from which I take them from core volume. The upper tribunal, as my Lord Kerr has identified, is the tribunal of fact. Their decision starts at 138. I just want to take up a couple of references by way of context.
Remind me, I should know, the appeal to the upper tribunal is on fact and law.
That's right. It's
Yeah.
effectively a de novo hearing.
Yeah, and in fact, they made new factual findings, didn't they, the upper tribunal?
I'm sorry, my Lord.
They made fresh factual
Yes.
findings.
They did. And we're all, like them or lump them, we're stuck with those. That's the
Yeah,
basis on which the appeal
right.
must be determined. And
Right.
nothing I say in any way dissents from that.
No.
And I take it that the court's had the opportunity to read it, so it's all familiar. So I will just point out one or two points and indicate why I'm drawing them to your attention. So from paragraph 12, the tribunal in paragraph 12, based on their inspection, contrast the Iceland's air handling system with the very much smaller units for larger adjoining stores. That's it within paragraph 12. They note in paragraph 15, as the court will appreciate, the particular concentration of frozen and refrigerated food within Iceland's store. Importantly, to understand the context of this case, they identify in 18 and 19 the distinction between integral refrigeration cabinets and remote refrigeration cabinets. And just to encapsulate that, the integral refrigeration cabinets effectively throw heat out into the store, which creates a situation which, on the findings, as you'll see, the air handling units is designed to deal with that situation, which wouldn't arise if you were using remote cabinets. And that's explained in 18 and 19. 21 is the finding that of the 82 cabinets in the Iceland store, 81 of them are of the integral variety. In paragraph 22, it's noted that the air handling unit functions all of the time, and its characteristics are set out in paragraph 23. It has various grades of cooling, either free cooling or a more interventionist mechanical cooling. That's described in paragraph 25, and in 26, as a finding, just to give an indication of the scale and the 24-hour nature of the operation, there's a finding that the highest stage of intervention, in other words, the mechanical cooling, was required on 123 days when the store was closed. And 30...
Is it 123 days or 106?
106.
Oh, I'm so sorry. It was required 123, of which 100. I'm so sorry.
Yeah, no, that's
100,
all right. No,
106 were when it was closed. A large degree where it's required when the store is in fact closed. I apologise.
No, it did.
And at 36, may I just draw attention to? I may, before we get to that, may I just draw attention to 23, which I took quickly, but I just want to draw attention to it. So the characteristics are described, including the fact that there is a single sensor, there's no localized cooling, and that there's a high degree, a 2 degrees variation in temperature. I just draw attention to that in the light of the points that Mr. Mooreshead makes in his written case. I'll explain why in just a moment. For the same reason, I draw attention to paragraph 36, which the tribunal records as evidence, and I suggest does form part of their findings of fact. They record the fact that evidence was given by Mr. Parry as to his responsibility for designing and operating the system, now installed in 90% of its stores. Its equipment is unlikely to suit the needs of other retailers, and systems left in place and effectively when Iceland swapped stores, it took over Marks and Spencer's and vice versa. Effectively, they started again in terms of the relevant equipment because it was said it wasn't suitable. And that...
Can I just say, just because the cabinets themselves are not part of what we're talking about.
Well, they're not, my lord, but we need to just think about the cabinets, which I'll come on to. What they are, effectively, is an item of non-rateable plant.
Yes.
They're a fixture. Some of them are fixtures, some of them, but they're basically non-rateable
I
plant.
mean, the ones described in paragraph 18, these integral or remote, I mean, that doesn't really matter for these purposes. Because what we're talking about is this thing outside the building described in paragraph 12, and the system which
Isn't it because they're integral? In other words, they're capable of being moved, in theory at least, that they generate heat into the ambient atmosphere of the shop, and therefore you need the bit of kit we're talking about now.
That's right. That is right. That's absolutely right. And the advantage of the movability is nothing to do with the air handling system. It's to do with using that type of freezer. That is what gives the flexibility. If you're doing that, which most retailers don't do, then you need to have a form of specialist air handling unit. That's the factual context of it. To deal with the point that I think perhaps arises from Lord Carnworth's observation, I'll come on to it actually as I develop my submissions. In terms of rateability of the machines themselves, the refrigeration machines, the position is that none of them are rateable, whether they're integral or remote. They are a classic example of non-rateable plants, and I'll come on to show why they're non-rateable. They're non-rateable because the scheme never puts them into rating.
Yes, but at the back of mind, what all this is about is a tax system which taxes the letting value of property, or hereditaments, in this case hereditaments of building. And so one's asking oneself how to distinguish between the things which are properly attributable to the hereditament and the things which are properly attributable to the trade of the tenant carried on within it.
Yes.
And of course we get these grey areas where people for the last 100 years have been struggling to find the sort of
My lord, precisely, and the proviso that we are concerned with is, if you like, the front line of one of those boundaries. It's a functional division, and we'll see how it works and what it relates to. But that's exactly right. We are differentiating between that which is, as we've put it in our case, we say it's that which is essential to the property that's being valued and that which is accidental to the particular type of operation the tenant happens to be doing.
The problem is that it's not always possible to place those in hermetically sealed compartments. There's bound to be a crossover to some extent in that, if you've got a hereditamент, which is obviously going to be let for some sort of retail purpose, you can't lose sight of the circumstance that retail purpose may involve something such as refrigeration and so on. There's no sharp distinction to be drawn, is there?
Well, my submission is that if one thinks in terms of the valuation doctrine that you value in terms of the mode and category of occupation, the general principle would be you're seeking to value a shop, not a shop that specialises in the sale of frozen and refrigerated food.
Yes, quite. But, I mean, a shop, which is a retail outlet, will have certain attributes or certain equipment.
Yes.
Conventionally.
My lord, and it would conventionally have air conditioning system.
Yeah.
And it's said against me that it's unfair that the impact of my argument is that the non-main part of this that serves the hereditamент comes for free under the rating system. I'll show you that's a deliberate choice of how Parliament has chosen to draw the line. They could have apportioned it, they could have introduced a test of Soli, they didn't. They went in with their eyes opened and they said that's effectively a classic impact of having classifications. There might be winners on either side of the line. If I'm right, we're a winner in that respect, but that's a deliberate function of the legislation.
Right.
Can I ask, if you think about any supermarket, it's likely to have an air handling system, and it'll be designed to cope with the various sources of heat that there are within the supermarket. It may be people, lighting, equipment such as chill cabinets, which may produce heat. And so you'll have an air handling system that is able to maintain a comfortable ambient temperature, taking into account the various heat sources that there are. Now, as I understand the argument, what's special about a retail supermarket operated by Iceland, or I dare say other firms with a similar business model, is that the freezer cabinets give out a large amount of heat, and there are a great many of these cabinets. So the consequence is you then need to have a more powerful air handling system than an ordinary supermarket would require. Is that right?
Well, that's basically right. But in the proceedings below, there were two issues. One is whether we are knocked out at the threshold stage, which is the one that's in this court, and the other is taking account of the fact that the provision of air conditioning is a natural part of service for the hereditament, the fact that customers are being cooled by this, staff are being cooled by this, whether taking account of that, which in the upper tribunal was a substantial factual debate, although the tribunal thought it shouldn't have been. They thought it could have been approached in a much more straightforward way. And in the valuation tribunal, it was all disposed of in a day. But that's the issue too, where the tribunal wrestled with that and decided that it was mainly used for the purpose of the cabinet. So my lord is absolutely right, and that we didn't get to this point without engaging with that, but we did engage with that in the upper tribunal, and that's what we got out of the upper tribunal, the finding that if we weren't knocked out on this point, we would have passed the mainly test.
Yes, I'm just trying to think my way through this. So if you had a supermarket like Sainsbury's, for example, you would have cabinets to keep cool milk and yogurts and cheeses and meat and fish and all the rest of it. You would have some freezer cabinets as well, but they might not pass the mainly test if the evidence was that even on your argument about trade processes, because I suspect if you're right that keeping a frozen chicken frozen is a trade process, and keeping a bottle of milk fresh is probably a trade process as well. But if on the evidence the main purpose of the air handling unit wasn't to keep meat, milk, etc. Fresh, but was to keep customers and staff at a comfortable ambient temperature, then they would fail to qualify for the relief. Is that right?
That's basically right. The other factor just to bear in mind is if, as they typically do, they have a much different concentration of integral and remote refrigeration. If it's remote refrigeration, that's effectively non-rateable plants. The pipe work taking the heat out of the store would be non-rateable plant as well, and this issue just wouldn't arise.
Yes, I see. So really, if they were using integral, I beg your pardon, if they were using remote cabinets, then you can just ignore those for the purposes of this argument, and that makes it all the more difficult for them to qualify as having air handling mainly for the purpose of a trade.
Yeah, and they would. I mean, factually, we say they just wouldn't have a system that was anything like this. But if they tried to run the argument, obviously, my submission would be they'd have to show a linkage to effectively an activity taking place in the store. We say the relevant activity is the use of equipment to continuously refrigerate. So they'd have to show that. And also factually, they wouldn't actually use that because this is just, we say, materially different from the way they operate. But insofar as it's useful, remote refrigeration, none of these issues arise because they're just outside the schedule.
Yes.
So, supposing your shop has, in addition to the kind of things that Lord Reed mentioned, a hot food counter, which some of them do, selling pizzas or whatever for lunch, which generates quite a lot of heat. Is that the same? Does that give rise to the same sort of question?
Well,
are we back to wholly or mainly again, or is it simply a case of having an air conditioning system and using it a bit more than some other people do?
Well, no, it's the stages of the analysis are: is there's an air handling system which is prima facie within Class 2? Mm-hmm. Then the critical question is there an activity taking place that's capable of being described as a trade process? I say that there is, because here there's a continuous intervention to keep the
Yeah, well,
keep
cooking pizzas might be a process. I suppose.
I wouldn't dissent. I wouldn't dissent from that. And then you're looking at the relationship between the particular part.
So you're back to wholly or mainly, are you?
Well, I'm
Or
not
aren't
sure you are, because I think on my Lord's example, you never get into the schedule. I don't think on a food heater that's placed in the store you ever get into the schedule.
Why?
Because I'll show you when you come to the scheme, but the scheme, the short answer to my Lord, the scheme only puts certain things on the hook for rateability.
No, I'm not thinking of the cooking equipment. I'm thinking of the air conditioning equipment. But anyway, come to it when you do.
Well, I mean, the short answer to my Lord's point is if we had a situation where there was part of the air handling kit that was actually serving only a heater, or mainly a heater that was doing this, then the logic of this argument would cover that situation. But I'm not sure it's likely to arise factually.
I suppose to take it a little bit further, if you were talking about a pizzeria where the main heat source, and with an open kitchen, and the main heat source in the premises is the pizza ovens, then your argument would be a runnable argument in that situation.
Yeah, if there was an activity that was particular and it required a piece of kit that effectively was mainly serving the non-rateable plants, then I think the argument would apply. I don't resolve from that. I say that's a deliberate feature of the scheme, in fact.
Right.
Although one would have to perhaps grapple with, and the tribunal of fact would have to grapple with the extent to which what was happening was part of a service to heritage, taking account of the fact that in that example it was the mode and category of a restaurant, so one would expect some sort of intervention in a restaurant situation. Just quickly on the facts, and because the discussion's already kind of moved past them, but I just want to put down two last markers, please. 48E was Iceland's case that specifications and design, so that's on page 148. The specifications and design of its system would not be useful to an alternative occupier who did not have the same quantity and cabinets rejecting heat into the store. We've covered that in the discussion, but that's where the tribunal record that. And all of those references are the context for the point that's used in Mr. Moorehead's argument by reference to paragraph 122, where the tribunal records in the valuation stage of the argument, the notional landlord must be taken to appreciate that the system is too powerful to meet the needs of most tenants in the market for a retail warehouse. Now, I don't resile from that as an observation, but the context of that observation is all of the differences that are previously set out. And I do say, and just to note that there is a difference of where the facts take us on this, in paragraphs 4, 67, 105 and 123, Mr. Moorehead summarises, or the respondent valuation officer's argument summarises the issue as if it were only one of overcapacity. And I say that on the findings of the tribunal fairly analysed, that is an oversimplification. And if I can just be forgiven a quick metaphor to demonstrate my point, if I do the school run for my 3 children in a coach, it's correct to say that I have an excess of capacity, but it wouldn't be a sufficient explanation of the unsuitability of that particular mode of transport. It's the same basic thought. It's over-specification. It's designed for a different purpose, and it isn't fit for the comfort cooling requirements that would normally be deployed by a retailer. And all of that, I say, is there on a fair analysis of the tribunal's findings. So those are the facts very shortly. I've already mentioned in discussion in relation to a question that Lord Reid asked the tribunal's approach to the mainly findings, and just you'll have seen those are in paragraphs 68 to 79, and they're carefully set out in the tribunal's findings, and there's no cross appeal in relation to those. So that point is effectively established for the purpose of these proceedings. I very, very briefly just want to in the light of the arguments that we now face, just go back to show one reference from the valuation tribunal and to make 2 very quick points. So that's at core volume MS 168. I apprehend that the the court, and perhaps in particular Lord Carnworth, given his former role, will be interested in the extent to which any outcome of this court is workable in practice in the tribunal. So I do observe that whilst we had a 4-day hearing in the upper tribunal, in the valuation tribunal, the whole thing was actually determined within 1 day. They were and are, in my submission, equipped to make findings of fact in relation to the Mainley test. I say that this argument that we're advancing doesn't cause insurmountable problems at the lay tribunal and expert tribunal stage. There is a finding of fact, there's a difficult call, there is a boundary, it's a function of the scheme, and the tribunal is equipped to deal with it. That's the first point. The second and last point on this is I just want to call attention to paragraphs 19 to 22 of the valuation tribunal, where the approach that was being urged by Iceland's surveyor in his evidence and analysis to the tribunal was parasitic upon the guidance contained in the valuation officer's rating manual in relation to computer suites, and the analogy is made at 21 and 22, effectively reflecting a submission that it's a small step from the acknowledged exemption from rateability of air handling systems that serve computer suites, as recorded in the guidance promulgated by the valuation officer, to effectively substitute an integral cabinet for air for computer. And we put that at the centre of our argument, relying on what we perceive to be the orthodoxy right at the beginning of these proceedings. The argument has taken a different course, and we are where we are, but it is important for the purpose of my response to Mr. Morshead's argument to point that out. The second point I'd like to make, just in terms of the shape of the argument that we now face, is if you go to see how the upper tribunal dealt with this matter, so that's within the core volume at MS 136. Oh, I'm sorry, that's the wrong. I'm so sorry.
Appeal, I think.
138.
Sorry, that's the wrong reference. 147. Forgive me. MS 147. The approach that we're now debating effectively flows from the submissions advanced on behalf of the respondent valuation officer in paragraphs 44 to 46 of the upper tribunal, and just draw attention to those. They're effectively construction arguments, pure and simple, and they found favour in particular in paragraph 65 of the upper tribunal's decision, which crystallises those points that we say are wrong. And then the shape of the argument proceeded to the Court of Appeal, where there was a substantial amount of historic material being advanced to say that that was the wrong approach, and the criticisms of that approach were encapsulated at paragraph 12 of the Court of Appeal's judgment, I think by reference to our grounds of appeal. And it's perhaps helpful just to turn those up. There were three main lines of attack. First, that it's unduly restrictive to approach this as an exception for plant and machinery. Rather, it's a proviso. And so the narrow approach is the wrong approach. That's the first ground on paragraph 12 at MS 127. Then there's the transition point, which remains at the heart of our case. And then there's a third point, which I'll call, as the Chancellor did, the remoteness point, which was, it was wrongly thought that it was relevant to suggest that the air handling system was more remote from Iceland's trade process because it was cooling the hot air produced by the storage cabinets rather than cooling any hot air produced by the preservation of the frozen food itself, the remoteness point, which was part of the upper tribunal's reasoning, but the Chancellor distanced himself and rejected that in paragraph 44 of the Court of Appeal's decision. So it's really those first two limbs. It's wrong to approach this as an exception and as a narrow exception as a matter of approach. And secondly, transition is a wrong turning in the analysis that is the heart of Iceland's case in this court.
Can I ask just a matter of information? Do you happen to know if there is analogous legislation in Scotland?
My lord, yes. And may I come back to that?
Ah.
Because there are two references to it. One is it's dealt with in particular in the Wood Committee report, and there is one case that bears on that I do refer to, and I will take.
Well, the Grangemouth one.
I beg your pardon?
The Grangemouth one?
It's the BP
Yes,
and Lothian
yes.
case.
That's nearly 30 years ago. I wondered if there might be anything more up to date than that.
Well, that's the one that we have. That's the one that we found. That the terminology, the proviso, and it's a slightly different. It's same purpose, slightly different shape of legislation, and the wording is industrial or trade process in Scotland.
And I'd wondered if the issue that we are dealing with had actually arisen.
Not according to our researches.
And is that because the what are they called? The valuation officers in Scotland have accepted Iceland's argument?
I'm not sure that we can take instructions on what the position is in relation to the Scottish stores. I'm not sure that. I'm not sure. Can I get back to the court on that?
But you've checked. I mean, we've checked on the current legislation in Scotland, have you?
Yeah, yes. I mean, it's not the same, but it's the same structure. And I think if I can take it when we get to the Wood Committee, there's some helpful references on that, and I'll deal with the BP and Lothian case there. But effectively, it's the same structure of the legislation.
Can I just, before you carry on, see if I can be sure about the parameters of the argument? Going to the chicken, which seems to feature quite regularly. Is it right that it's common ground that taking it from its natural state of, let's say, room temperature to frozen would be a trade process?
Certainly, that was I certainly say it would be.
Well, I know. I'm asking if it's common ground.
And the Chancellor's reasoning said it would says it would be in terms. I would imagine that it does meet Mr. Moorehead's test. So
Okay.
yes.
But preventing it from returning to its natural state is not.
Well, that's the argument against me, and I say, in short, that when the Chancellor formulates the nature of it in paragraph 41, it's a very, very small step to add preservation to the list that he articulates as the essence. Another way of saying it would be we're actually changing it from a state of perishability to one of being capable of being preserved. It's just a linguistic change. But the key point is the process actually is an intervention, perhaps, and certainly in this case, but perhaps necessarily involving the deployment of equipment. That's perhaps a choice that needs to be addressed. You'll see in the Hayes case, there's where the creation of the environment is said to be a process. That's criticised by the respondent, and maybe that's a higher level of abstraction. But the basic thought, we say, is that it's the intervention to using equipment, in our case, and perhaps necessarily, to achieve a particular end. And if that end is preservation of that which would otherwise deteriorate, that's a logical consequence of it being a trade process. So, my lady, that's our main complaint, effectively. That's our ground two. Our ground one is that this is a deliberate structure. The proviso is deliberately structured in the legislation to be much, much wider than everybody thought it was. But my ground two is a freestanding point. I'd respectfully say, could disagree with my analysis on ground one, but if I'm right that that's within the ordinary meaning of a trade process, then ground two is designed to achieve that outcome if the court is with me on that, but against me on the wider points. May I then go to the 2000 regulations, which are the provisions that are critical for the purpose of the arguments, and they're within the authorities volume, and the regulations themselves are at tab 2. It's perhaps worth just showing the court the vires of them, just for completeness, which is tab 1, page 185, and it's schedule 2, subparagraph 8 of the Local Government Finance Act of 1988, which is the parent provision of the non-domestic rates, and it's a simple vires provision that the Secretary of State may make regulations providing that in applying the preceding provisions of this paragraph, which are all to do with the valuation test in relation to a hereditament of a prescribed class. Prescribed assumptions as to the hereditament or otherwise are to be made. And these are prescribed assumptions as to what should be taken to be the hereditament.
So it's section 2.8, is it?
2.8.
Yep.
And just for completeness, section 56 is just an enabling provision to Schedule 6. It enables provisions as to valuation. Schedule 6 enables the 2000 regulations. So if the court would then please go to the 2000 regulations themselves, they're to be found at tab 2, page 195. You'll see the virus is recorded on the front page there as 2.8 of the Schedule 6. May we go, please, to Regulation 2, prescribed assumptions as to plant and machinery. And I just do ask the court to pause over this enabling provision. So for the purpose of determining the rate of value of a hereditament,
Which one are you on?
I'm
Two.
Regulation 2, which is the top of MS 196, my lord. So for the purpose of determining the rateable value of a hereditament for any day on or after the 1st of April 2000, in applying the relevant provisions of Schedule 6, in relation to a hereditament in or on which there is plant or machinery which belongs to any of the classes set out in the schedule to these regulations, the prescribed assumptions are that the plant and machinery is part of the hereditament and the value of any other plant and machinery has no effect on the rent to be paid. So in other words, if it's in the schedule, it's in the hereditament for the purpose of valuation, and you do have regard to its value, but none of the other value of things that aren't in the schedule. But critically, in relation to any other hereditament, the prescribed assumption is the value of any plant or machinery has no effect on the rent to be estimated. So we need to concern ourselves not just with what's in the schedule, but with what's not in the schedule, because what's not in the schedule never gets caught by the rateability provisions.
So, sorry, the listed class stuff is rateable and the rest isn't. Is that basically
Correct.
it?
Everything else, there's a very large residual class of things that aren't rateable at all by virtue of never making it into the schedule. And it's a feature of the analysis in the courts below, which may reflect the way it was argued, but which is being certainly corrected in this court. It's a feature of their reasoning that they don't actually grapple with what's outside the schedule and why it's outside the schedule. And that is an important point in understanding the proviso that we're concerned with, which effectively mediates between service plant that should properly be attached to the service plant in the schedule and service plant that I will say is outside of that because
Never gets in there at all.
its purpose is to serve effectively non-rateable plant, be it factories in the machine, in a mill, in Townley Mill, be it computers in a computer suite, or be it cabinets in a retail supermarket. That's how you make sense of this legislative scheme. That's effectively the force that comes from the need to appreciate that many, many things are never rateable by virtue of the effect of 2B of the regulations. So my point just to make clear is that Regulation 2 applies to all hereditaments, but 2B takes out of rateability a great many things by virtue of them not featuring in the schedule. So the examples we were discussing earlier, integral refrigeration, I say you just won't find it in the schedule, therefore 2B makes it non-rateable. Our freezers themselves, the integral ones or the remote ones, same answer. The mainframe computers in the computer suite, same answer. 2B makes them not rateable. The factory machinery in Townley Mill, same answer. They're not rateable because of 2B. So in a sense, perhaps the purpose of the proviso is that it's going to be that properly understood, that bit of kit, which but for its role in the tenant's activity would obviously be serviced plant, actually is something that's an accessory to the non-rateable plant. And the proviso is actually helping to mediate between are we rateable plant under Class B, or are we actually an adjunct or accessory to non-rateable plant, which is actually what's always been understood by the old-fashioned term process plant as distinct from motive plant. That's how it's used in the short report, it's how it's used in Townley Mill, and it's that concept that the phrase trade process is trying to capture, not productive industrial activity. That's the essence of the case. So the key point on the regs, on Reg 2, is you need to think about outside the schedule. Then, obviously, you also need to think about inside the schedule. So I'm going to go on to deal with the classes in the schedule. For reference, I do deal with these in writing in paragraph 61 of our written case, and there's some references to the Wood Committee report where there's expressions of purposes within them. But it is useful to understand the structure of the regulations themselves in the schedule. So if I could take them, we're concerned with Class 2 and the proviso to Class 2, but if I just take the other classes first before we concentrate on Class 2. So Class 1 deals with power. So that's on MS 198. And power to the hereditament is in. The rule applies by virtue of a complicated series of definitions. First, transformer, and then primary transformation of power, and then main transmission of power. But where you get to is that power is presumptively in up to, in the case of electrical power, the first distribution board. That's Class 1, C1. It's worth noting two things just for context. The phrase manufacturing operations and trade process does feature in this class under the heading of transformer in Class A. You see that right at the foot of MS 198.
Well, yes, that's to take out something which is, as it were, built into some other piece of machinery.
Effectively, it's the same function of the proviso, but it's actually, it doesn't have as much traction because actually, in the case of power, one's only actually interested for the purpose of this class with what's on the supply side of the first distribution board. So it actually is less in the front line of the boundaries. But the same phrase appears, and that's worth noting. The other thing that's worth noticing is there's a concept of accessories to rateable plants, and the rules for those are followed. You'll see that referenced in the operative bit of Class 1, so it has to be in Table 1 to be operative, together with any of the appliances and structures accessory to such plant. And that's in the table that you'll see at MS 202. And it's right to say that the accessory concept is common to classes 1 and 2. So you can have an accessory to rateable service plant, which is itself rateable by virtue of being in the list of accessories. A way of conceptualising the function of the proviso in Class 2 is that what it's actually trying to catch is the equivalent of an accessory to a non-rateable bit of plant, a cooling system that serves a computer or a factory. But the concept of an accessory to rateable plant is there on the face of the scheme. Class 3, I can deal with very briefly, it's infrastructure. In the written case, we refer to the Wood rationale explanation of this in the Wood Committee, that it facilitates a wide range of possible uses and therefore enhances the rateable value of the property, which is the same general conceptualisation that was advanced for the service provision and is the same provision, effectively, that's the rationale for service. So a way of exploring it by way of rationale is, does the air handling plant, knowing what we do about the way it operates and what it relates to, what it's designed for, what it's mainly used for, does that serve the hereditament or does it do something different? Does it serve the non-rateable plants? Class 4 is interesting, and Class 4 is effectively puts things into rateability, but then takes them out unless they are sizable enough to pass various size thresholds. So the key size threshold is if they're in the nature of a building or structure. So they're sort of in, but then automatically out unless they're caught by the size provisions. And that's
Extraordinarily elaborate.
Yes. But that,
I mean, to decide what is the exception, what is the norm, is almost impossible without the interaction of things being brought in, taken out, brought in again. Very, very detailed.
yes.
For what it's worth, I've got the Scottish equivalent here, which seems to be exactly the same term.
I remember,
Mr. Kalinski in business.
Sure. And Mr. Morshead.
well, I
I
remember in my youth being kept in business by cases which turned on the degree to which the plant or equipment was fixed to the hereditament. And it really is a question of property law. Was it part of a hereditament or not? And it looks as though that source of bar income has dried up as a result of this legislation.
that was the essential debate in which
We had the whole debate in the tax context for that.
That's why my lord took appointment to.
But the provision of Class 4 that's the one that's in the front line of the industrialist's dissatisfaction. That's the subject matter of the Ritson and the McNair report that Mr. Morshead relies on, that I say don't actually bear on the issues with which we're concerned. And you can see why, because it's sizable machinery, even if process plant, is caught by virtue of its size.
Yeah.
So that's where the litigation was, because that was the one that actually caught them. And they were saying there should be a general rule that process plant is outside. Answer, no, that's not the right way to draw the line. Class 4 is the right way to draw the line. Everybody proceeding on the basis that there was this thing called process plant that was outside of it because of what's now 2B. It used to be section 24 of the Act. It's now regulation 2B of the 2000 regulations, which takes things by mere fact of their omission from this schedule, they never get into rateability.
Right. But how are we doing?
So we've done the regs, so we're doing pretty well. Sorry, we haven't quite done the regs, my lord, because I haven't really shown you Class 2, and I do need to show the court Class 2 to show where the proviso comes in. So perhaps we just go to MS 200. Plant and machinery specified in the table below, together with appliances and structures accessory to such plant and machinery specified in paragraph 2 of the list of accessories, so together with accessories, which is used or intended to be used in connection with services to the hereditament, so a concept of serving services to the hereditament or part of it, other than, and here's the critical proviso, such plant or machinery which is in or on the hereditament and is used or intended to be used in connection with services mainly or exclusively as part of manufacturing operations or trade processes. And it's common ground that services include cooling and that all the bits of equipment are within Table 2. So we're dealing with the approach to the proviso on which this case turns.
Yes.
So that's the introduction to the regulations. May I just try and do a very quick, but there's one or two stops that need to be dealt with more slowly, but sort of chronological journey through how this came to be in the 2000 regulations. So I'll do it where I can just by referring the court to just reminding the court of where it's dealt with in the written argument. So the pre-Kirkby situation is dealt with where there was basically a creeping debate about the landlord principle of attachment. We described that in paragraph 20 of our written case, which is core volume page 55. You then get the debate in Kirkby itself about whether that should be abandoned. Effectively, one should move away. About the abandonment of attachment as a principle, effectively then catching plant, albeit in the context of the argument in an industrial setting, but whether or not it's attached, and the court saying effectively it's too late, too well entrenched to turn that back, and therefore the situation is that plant is prima facie rateable on the basis of Kirkby, albeit articulated in an industrial setting. So that's the Kirkby position. It catches all process plants, whether or not attached. It's that which gives rise to the dissatisfaction and the discussion of a new system in the Short report. And it's that to which Short articulates the boundaries, the principles behind the boundary of classification, and then we see what Parliament did with it and how the courts have approached it subsequently. So I think I can take all of that very shortly and then go again briefly, I hope, to the Short report itself, which the court will find in Authorities Volume 4, tab 31, page MS 1033. And I'm conscious that this is a document that's extensively referred to in the written arguments and actually is several steps removed in terms of background from where we've got to. So I propose to just identify what I suggest is the critical passage of this relatively shortly. So I've described the circumstance which gives rise to this, which is some growing dissatisfaction with the boundaries and implications of the Kirkby decision, which is described in this report as the Hunslet decision, but it's the same decision. It may be worth just noting in passing in paragraph 4 that there's a discussion, there's potential doubt about how far this would extend, whether it would apply to furniture in a hotel, fittings in a shop, office or warehouse, but in practice no attempt yet, the committee say, has been made to extend the principle, but they're seized of the idea that if we sever the concept of annexation, there's no logical stopping point to that potentially. They then discuss the grievances with this, largely advanced by the industrialists, it's fair to say, unsurprisingly, because they're in the front line of this. And then they consider how to draw lines and how to create classifications. And it's paragraph 15 that's I would respectfully suggest is the paragraph that is worth noting. They are looking to make things better for the industrialists. That's undoubtedly part of the context. To give effect to this recommendation, it's clearly necessary to draw a line which will divide machinery and plant into two classes. That's paragraph 15 on 1049. Class 1, which will be the subject of full rating, and Class 2, which will be an entitlement to a fractional or differential rating. Now, that was 25% as they proposed it. This was never implemented because Parliament drew the classifications on the basis of full rating in the schedule and full exemption outside the schedule. So
that's another expression for apportionment, is it?
It's not quite apportionment, it's just a discount. It's a discount.
Thank you.
And they say, and this is the bit that we say is potentially of some significance in understanding what the governing concepts were thought to be. As to the general line of division, there appears to be practical agreement, the principle recognised being to include in Class 1 motive power such plant and machinery as a landlord would normally provide, or everything except process machinery. And then they discuss difficulties of framing it, impossibility of a clear line, they comment that it appears to us that this is a third of the way down page 18, internal page 18. It appears to us that the only practical plan is to define certain classes of machinery and plant by reference to the purpose which they serve. That's in the context of wanting to future-proof any legislation, effectively. Let's look at the purpose, because conscious that things change, lists go out of date, so let's allocate it based on an understanding of the purpose that it serves. And then it's fair to say that the line they drew was for service plants to be, if you like, all in the full rate capacity, but that changes when it goes through Parliament. But they do say that these classes, and this is important, at internal page 20, MS 1052, they do say that their proposals, which they formulate there, apply to all rateable hereditaments, except for certain special cases which we're not concerned with, but they're effectively what become, I think, the central list cases. So that's short. The critical point of short, I would respectfully suggest, is that there's a reaction to inconsistency and the potential reach of the Kirkby decision, which leads to the need for a system of classification based on an examination of the function that the plant serves and against a background of one of the key concepts being some kind of view on the allocation between what a landlord would normally provide. See paragraph 15. So the short proposal in that form never saw the light of day. 1925 Act was drawn up. As I said, the classes were either in or out, and the schedule quite closely resembles the 2000 regs, albeit the bits of it have been updated, but the basic structure of it's the same. Of interest to present purposes is how our proviso came to be. There is a parliamentary exchange that bears directly on that. I'll show you the exchange and I'll make short submission on its admissibility. The exchange is to be found at tab 32, MS 1070. So it's Mr. Neville Chamberlain, I think as he then was, dealing with this for the government. One word, picking it up a third of the way down the first column on 1093, one word with regard to the second paragraph, which deals with heating, cooling and lighting and so forth. I understand that the new words which my honourable friend desires to introduce are for the purpose of excluding from the operation of the clause such processes as, and I emphasise these words, as really belong to the precise work which is being carried on in the shops. And as I said in the case, I'm sure that means workshops, no part of the general heating or ventilating of the plant, but where, for instance, a man is polishing at a buff and there is a fan drawing off the dust so that it does not go down his throat. And then I emphasise these words, that is to be treated as part of the machinery and not as part of the heating or ventilation plant which is run. In other words, the proviso allocates by function between service plant, properly so called, and effectively an adjunct to the non-rateable process plant. He says that, just to complete the entry, that seems to me to be quite reasonable, and if he would accept the words which I suggest to him instead of his own words, then I would propose to accept his amendment, and so it came to pass. So that's how the proviso, in a virtually identical form to its current one, got into the legislation. The court will obviously want to consider whether that's admissible. I say that it is. We deal with this in writing in our written case by reference to the Brown case at paragraph 26, where Lord Toulson expressly leaves open the possibility of an exchange relevant to earlier legislation which is subsequently reenacted, because it's obviously a hurdle that I do need to surmount, but I say that it's not a hurdle of principle. I say this is admissible because it directly bears on the rationale for the proviso, which was introduced by way of an amendment. So it's particularly focused on the change that was brought about. So it's very specific to the wording that we're concerned with. And this is undoubtedly not a case that this court rightly depreciates of casting around the debates and constructing generalised statements. I'm not seeking to rely on any other part of the exchanges, just the one that bears precisely on the purpose of this proviso. And I say for that reason it does pass the admissibility threshold.
Well, of course, Pepper and Hart's a very interesting case for all manner of reasons, but interestingly, it requires preemptively that the quoted extract will provide an authoritative answer, and that is on the premise that there is a debate to be had about what the authoritative answer should be. And Lord Mackay, as one recalls, was apprehensive about the opportunity for introducing parliamentary debates, and to a certain extent, I suppose, his apprehension has proved to be vindicated in that we receive these extracts de bene esse, and it is a matter for some consideration whether or not, first of all, that there is the necessary debate about the construction, and secondly, whether the extract provides the authoritative answer. But, I mean, I don't suppose that there's any objection to receiving it de bene esse. We'll have to reflect on whether or not all of the conditions for Pepper and Hart admission are satisfied in this particular instance.
My Lord, I understand the wider significance and sensitivities of that particular decision, and if the Court's prepared to proceed to bene esse, I've shown you the extract, I've made short submission why I say it passes the test.
The Chancellor found it intriguing that you were quoting Neville Chamberlain, and so do we, I suppose.
There are some interesting historical cameos in these particular proceedings, it's fair to say, and that's one of them. So, my Lord, yes, I'll move on from it unless the Court wants further submission.
No, I think we don't need to go any further.
So the next stop, and I'm going to try and take a great many of these very shortly, but the next stop is the first decision, or at least that's how it was reported in the specialist rating and income tax report series. It's the Union Coal on the 1927 order, as it then became, and that's the Union Cold Storage and Southwark case, which the Court will find at Authorities Volume 1, Tab 6, MS 284.
Yep.
May I indicate that the report is quite small wording, so we actually have available, if it would help, anybody, an A3 version that's a bit more easy to read, if that would be of use. Rather than
That may be of use to those who have not decided to have their laptops.
I would certainly like to see it.
Yes.
Even those who do have their laptops may want to see it. Anyway, what do you want to?
Sorry,
Alistair?
So this is the first case under the Plant and Machinery Order of 1927. That's a document that is in Volume 4, and it might be of assistance to turn it up, but basically it has the same structure that we're interested in: service plant and plant in the nature of a structure, which is Class 1B is the equivalent of Class 2, and Class 4 is the nature of.
Thank you. Thank you very much.
Yes.
So so this concerned effectively cold storage facilities. You've got the material facts as they're set out in this report, and it's fair to say that they it's a very, very short account of them, but the material facts of the case stated by the London Quarter Sessions is set out in the first column, and these are large-scale, effectively, refrigeration chambers where the refrigeration is carried out on the premises by means of ammonia, as was the case in the 1920s. The interest for present purposes lies in two places, to take it as shortly as I can. First, in the arguments which were advanced in the divisional court, and secondly, in particular, although the other judges go to the same effect, but it's most clearly in the decision that's called the third judgment, Mr. Justice McNaughton. So the issue really was whether these were rateable or non-rateable plant, and a key issue was the interrelationship between Class 1B, which is actually misdescribed in the report as 1.6, but it's actually 1B, which is basically the predecessor version of our Class 2. It's the service plant class, and Class 4, which is still Class 4, which is in the nature of a structure. So if I can pick the argument up right at the foot of MS 294, which is the first page of the A3 version, refrigeration machines with cooling systems used in connection therewith were not liable to be rating. It was submitted on behalf of the ratepayer. if used for manufacturing operations or trade process, Class 1, and it says 6, but it should be B, Class 1B proviso, that class applied to cooling or refrigeration systems, and it would be surprising if the plants specifically taken out of that class were brought back in again under Class 4. So it's really a debate about the relationship between what's now Class 2 and Class 4. Here was Class 1B and Class 4. And it was said, well, if it comes out at 1B, it can't go back in at 4. But the whole argument proceeds on the basis that it is part of a trade process. That was the ratepayers' argument. The argument advanced by the rating authority, Mr. Constam, King's Counsel for the Respondent Assessment Committee, submitted that the cork lining, which covered over with concrete or with wood framings, became an integral part of the chamber. Without insulating material, the chamber would not be a refrigerating chamber. If looked at in this way, he submitted that the lining was clearly in the nature of a building or structure. Trade process plant or machinery was taken out of Class 1B, I'll correct what's in the report, by the express terms of the proviso, but that proviso did not apply to Class 4. So the interest in this is partly the relationship between those two classes and partly the common assumption in argument that the refrigeration would be a trade process, albeit here in the 20s on a different scale to that which is that we're interested in. And if we then go to I'll only go to the third judgment, but it's consistent with the approach in the other judgments, but it's most clear in the third judgment. So it's the last page of the report, Internal 164, heading the third judgment, Mr. Justice McNaughton. If I could pick it up almost at the bottom of the left-hand column, he says, now some confusion seems to have arisen from the proviso to the first class of machinery or plant, which is in the third schedule and in the order substituted for the first schedule, is to be included in the valuation of the hereditament. The first class in the schedule and in the order consisted of plant and machinery for the generation and transmission of power on the hereditament, and secondly, for the heating, cooling and ventilation and lighting of the building of which the hereditament consisted. The object of the Act obviously was to exclude from valuation plant and machinery installed for the purpose of manufacturing operations or for trade processes. That was the scheme of the 1925 Act, and it was apparent that machinery or plant installed for heating or cooling or ventilating and perhaps lighting the building might be machinery which was on the hereditament for the purposes of manufacturing operations or trade processes, and in order to secure what appears to have been the object of the Act and to make it plain that such plant and machinery was not to be included in the valuation, the first class contains the proviso that although the plant and machinery for heating, cooling, ventilation and lighting the building is to be included in the valuation, nevertheless, in the case of such machinery which is on the hereditament for the purpose of manufacturing operations and trade processing, the fact that it is used in connection with those operations and processes for the purpose of heating and cooling is not to bring it within the classification of plant and machinery which is to be taken into account of the valuation. So that's the approach, and this is the bit that bears on the facts. This particular machinery in question, the cold storage plant or refrigeration plant, is admittedly plant on the hereditament for the purpose of manufacturing operations or trade processes. If there was no fourth class in the schedule and no fourth class in the order, it would clearly be exempt from rateability. But there was, and it was held to be in the nature of the building. So although I accept you don't get much detail of the facts, and Mr. Morshead says in his written submission that based on another case you can surmise that actually 25% of the materials change state. That may be right, but it's not held to be an objective analysis. In my submission, that isn't the right distinction anyway. I accept it's a different setting, but I do say this is proceeds by concession upheld by the divisional court that refrigeration as a matter of general approach is within the concept of a trade process.
Right.
So that's Union Cold Storage, and that was obviously right at the outset. There's then the Towney Mill litigation, which is canvassed fairly extensively in the cases. It is obviously an important issue that went all the way to the House of Lords. So I will take just a few moments on the judgments of that, because it may, the discussion there may be of assistance in understanding how the scheme was understood in the first major decision in the higher courts on it. So if the court would turn to tab 7 of the bundle of authorities, and I'll try and deal with this as expeditiously as I can. It goes from quarter sessions all the way to the House of Lords, so I'm going to canter through some of the stages. But the quarter sessions, you'll see, I'll take it from the head note if I may, so 287. The quarter sessions found as a fact, so sorry, just to set the context, the issue is a silent mill. So effectively it's got machinery in it, but it's not in use. How is this treated under the statutory scheme, and does the statutory scheme speak to this such an eventuality? It's fair to say, a case that turns on approach to valuation. However, in doing that and in deciding on the right approach, the court does speak to the purpose and scheme of the 1925 Act, and it's of interest for that reason. So the quarter sessions found as a fact that there was no beneficial occupation of the Hereditaments as a cotton mill, but they were of the opinion that the company were in beneficial occupation of the Hereditament by reason of the warehousing therein of process plant and machinery, accessories thereto, and loose chattels. So that was the decision of the Court of Quarter Sessions. They then state a case, and in paragraph 9 of the judgment, which is at 289, carrying over to 290 and 291, the court will get an indication of what was consisting of that plant in paragraph 5 and paragraph 9 of that stated case. And I just draw attention to those. I won't take any time on them. The appeal from the quarter sessions decision goes to the divisional court. The main judgment is the judgment of Chief Justice Hewitt that starts at 297, using the MS number, 595 of the report itself. The critical part, he makes observations at 596 about the facts and the way the schedule is drawn up, just to draw some attention to that. But then he says at 597, the matter of fundamental importance, as it appears to me, depends upon the particular provisions of the 1925 Act, especially section 24 of that statute. And then in the critical passage at 598, which I do set out in our written case, he encapsulates the distinctions that are found expression in the third schedule of the Act. And I perhaps won't read them out, but I do invite the court's attention to the passage that starts when one turns to the third schedule and the discussion there about the use of the terms process and motive plants, and the purpose of the legislation being to remove process plant effectively from rateability.
Yes.
That's the critical passage of...
Motive plant is the plant without which the mill could not work.
Yeah, which is essential, in the language of Dawkins, I would say, which is essential to the Hereditaments. Effectively, that's service plant, unless it's properly understood as being an adjunct to process plant or non-rateable plant. I think that Mr. Moorehead would draw attention to and rely upon, so I just note it in passing, 599 of the Chief Justice's judgment, where he describes Kirkby, and he says it was in this state of affairs, i.e., to put it very shortly, clobbering the industrialists by virtue of a fixation not being a requirement, that the 1925 Act was passed. And he says this: nobody can read this Act without perceiving that it's manifestly designed to relieve the rating of industrial hereditaments. Well, that's true as compared to Kirkby. That is undoubtedly one of the things that they were trying to do, but that's not a complete explanation of the scheme which was enacted. Undoubtedly, the industrialists were better off, but everybody else was also outside of it unless they were expressly included in it in relation to their plant and machinery by in there. So it also helped other hereditaments. It also applied to other hereditaments. So
whatever its purpose, it had this incidental effect, you say.
well, no, I don't accept that. I mean, it's undoubtedly right that.
But it applies for industrialists and traders. I mean, there's no...
Yeah.
So you can't just rely on the fact that it applies to industrialists.
Well, my lord, I certainly submit that comment, which I draw attention to because I think it is used against me. I think it was used against me in the Court of Appeal. It formed the basis of the analysis that this background doesn't help my case, it hurts my case. And that's an oversimplification of what's being said here. What's basically being said is factually right. The scheme is better for industrialists than Kirkby. Absolutely right. But that's not a complete explanation of what's going on in this scheme. It's also, as my Lord Khan has indicated, it's better for all traders. They're not on the hook by virtue of the collapse of the annexation principle. They're outside of rates by a clear statutory provision, so they benefit as well.
Right.
But that's just to see where that debate goes. It then went to the Court of... So the decision, the answer to the silent mill, effectively, on the facts of this case, was to be found in 603 internally, 305 of the Chief Justice's judgment, which is effectively... that he says, in short, the statute, i.e. the 1925 Act, makes it quite plain that the process plant in question in this case is excluded from the Act. So he found the answer only in the code in the Act. And therefore his judgment was, as recorded in 604, to reduce the assessment to a nominal figure based on an agreement between the parties. That then goes on appeal to...
He seems willing to say that anything that's there for the purpose of carrying on work in the hereditament is non-rateable, doesn't he?
Well, effectively, he takes the broad line, which is, I would submit, is the same understanding of process plant as used in the short report, paragraph 15. Effectively, it's that particular activity that's conducted by the tenant is non-rateable. And yes, actually, it is happening in an industrial setting in this legislation, but that's not the complete explanation.
Never mind the industrial trade dichotomy, if there is one. What he's saying there is that anything that's in the place for the purpose of the work that's being done there is outside the rating.
The particular, I would respectfully say the particular work, but my lord,
I follow, all right.
I agree. And so that then went to the Court of Appeal. The Court of Appeal held, I don't think we need to take time on it, but effectively they held that the Act has no application to a silent mill, and so they restored the approach of the quarter sessions. It then goes to the House of Lords, where we have the speech of Lord Russell, and the speech of Lord Russell in effect reinstates the divisional court. The critical part of it is to be found at 428, where you'll see at 427, that's MS 355.
That's the internal page.
Sorry, my lord.
Which is the MS number, please?
MS 355.
355, thank you.
That's where the third schedule is referred to.
Yeah.
Sets out the provision that we're interested in, which in this case 1B, and the proviso of operations or trade processes, comments on the plant and machinery at 428. The plant and machinery referred to in subsection 1A include plant and machinery whose function is not to execute any manufacturing, operation or trade process, but to generate and transmit to or to warm or cool, ventilate or light the hereditaments in question. That may be conveniently called motive plant and machinery, whilst manufacturing or trade process plant and machinery may be conveniently referred to as process plant and machinery. And then he goes on to say, to deal with the question of the silent mill, how that fits into this classification. He notes at MS 357 towards the bottom that the judgment of the divisional court was based solely upon the interpretation of section 24 of the Act, and he agrees at 4:30 with the reasoning of the Lord Chief Justice that the answer was to be found definitively in the Act, and that effectively the process plant was outside of the Act and therefore was of no value. He then deals with the Court of Appeal's decision to the contrary at 4:30. The suggestion seems to be made at the bottom of MS 358. The suggestion seems to have been made that the provisions of the Act don't apply to a silent mill, and he rejects that. And can I pick it up at the bottom of 431? He says, the Lord Chief Justice, it seems to me, errs in two regards. And he's commenting
Lord
on
Justice, not the Lord Chief Justice.
Oh, sorry.
Yes,
So
yes,
sorry.
yes.
The Lord Justice.
I think we need to distinguish
Promoted,
between
yes.
the Lord Chief
The Lord-
Justice and the
Lord
Divisional
Justice-
Court.
The Lord Justice, it seems to me, errs in two regards. This is a passage directed to section 24, which is the equivalent of regulation 2. So it's the one that deals with all hereditament and classifies them. In the Act, it's in the schedule. In our regulations, it's in the schedule. So the Lord Justice, it seems to me, errs in two regards. There's no dichotomy or division into motive, machinery, and process plants. That's in the section itself, i.e., in the equivalent of Regulation 2, nor does the section deal with factories alone. It applies to all hereditaments with one accepted class, and it provides, with respect to the valuation of every hereditament to which it applies, that no account shall be taken of the value of any plant therein or thereon, subject, however, to the provision that motive plant and machinery, which it is to be observed may be found in a private house, shall be deemed to be part of the hereditament. He therefore aligns himself with the reasoning of the divisional court and rejects the approach of the Court of Appeal.
And again, perhaps at the end, at the foot of the page, just ramming the point home, the section is not directed to factories only, but is applicable in turn to the valuation of every hereditament, not valued on a profits basis.
I'm very grateful. That was the additional reference I was looking for, and that's effectively saying this is a scheme that covers everything. It actually covers a lot of things by excluding them from the schedule, but it's that realisation that the statutory scheme covers everything that becomes important. And as I think I've already said, but just why is this silent mill motive plant not rateable? Because it never gets into the scheme. That's what this case turns on. And that's the same with the computers that we'll see in a few moments. And it's the same, I submit, with our cabinets, and therefore makes sense of the proviso. So I think that's everything that I need to show the court on Townley Mill. And may I then, my next reference, and I'm conscious that much of this can be done quickly, and I do want to make sure I leave myself time to deal in particular with the Wood report, but I just go on a very quick journey through a couple of authorities, if I may. The court may be assisted by looking at the Edmondson case, which the court will find in volume 2 at tab 14, MS 462. This is in some ways Court of Appeal decision.
Yes?
Court of Appeal decision, in many ways a sequel to the Townley Mill case, because it's to do with a valuation debate. It's a textile factory for which production had ceased. There was a debate about how the disregard for non-rateable plant works in that context, and it's a majority decision of the Court of Appeal. The interest, for present purposes, is the way in which very experienced counsel on behalf of the valuation officer explained the statutory scheme. So may I just invite attention to MS 464, where the submissions of Mr. Fletcher, Queen's Counsel, at the bottom of the left-hand column are set out. He was leading Mr. David Mole on behalf of the Inland Revenue, and Mr. Fletcher's argument starts there. He bases his argument on a number of propositions, most of which are not in dispute. In the first place, it must be borne in mind that Section 21, now that's of the 67 Act, which is basically the successor provision to Section 24 of the 1924 Act, applies to all hereditaments which do not fall to be assessed on a profits basis. That is not simply factories, but all premises, including, for instance, shops, offices, and the like, in which plant falling within the broad description of process plant may be used. There is no dispute here that what falls to be valued in the hereditament and what is not inside it or attached to it, except insofar as what is inside it or attached to it constitutes motive plant. So there was no dispute other than on motive plant. Thus, it was common ground that, however the value is to be assessed, the process plant is not to be included as part of the hereditament to be valued. And he then launches his valuation argument, but he does it by reference, first of all, to the Dawkins case, which is the same, has echoes of the way we put the case in our written case. And then he gives a very revealing example of process plant outside the scheme in a non-industrial context, because if I pick it up, 153 at the bottom of the right-hand column. Thus, Mr. Fletcher argues the accidental fact that the actual owner has chosen to use or permit the premises to be used for a particular purpose, which involves the introduction into and the fixing within the hereditament of process plant, whether valuable or valueless, is entirely immaterial. This is a valuation officer's case in this case. An occupier can, of course, increase or reduce his liability for rates by making structural alterations, etc. Leave out a bit and pick it up. Equally, if for his own particular purposes he introduces into the premises process plants and machinery which takes up space, this again is accidental and cannot be prayed in aid either as increasing or reducing the amount which the hypothetical tenant can reasonably be expected to pay. Thus, if one supposes two identical shops in a parade, one of which is empty and one of which has been equipped by the occupier as a laundrette, that's Mr. Fletcher's example, the hereditament to be valued in each case is the same, and Section 21 precludes the valuer from taking into account that a tenant for the laundrette might in fact be expected to pay a higher rent because he would be taking premises already equipped. Equally, supposing that the trade of the laundrette in the area is generally recognised as being a thoroughly unprofitable one, the existence of the laundrette equipment, which requires to be removed before the hereditament can profitably be used for any other purposes, is logically entirely irrelevant. So he pins his colours to the mode and category of occupation classification. He pins his colours to the fact that there's a large amount of process plant outside of the scheme in a non-industrial context, and he gives a very good example, washing machines within a laundrette. Of course, it's not a case dealing with the proviso, but it is a case that opens up a realisation that what's outside the schedule is absolutely critical for the purpose of understanding what the proviso is designed to allocate. It's designed to allocate between service plant, properly so-called, and a cooling plant in our case, that's properly to be understood as mainly an adjunct to the non-rateable process plants, to use the terminology of Short, to use the terminology of Townley Mill, and now to use the terminology of Mr. Fletcher in the Edmondson case.
And halfway down the left-hand column on MS 465, Lord Justice Oliver says that he's persuaded by Mr. Fletcher's argument.
But yeah, he succeeded. It's fair to record that the valuation argument we probably don't need to go into, and there was a dissent from Lord Justice May. The interest is in the presentation of the argument in, I respectfully submit, a way that very strongly resembles the way we put our case and is very remote from the way in which the valuation officer puts his case in these proceedings.
But apart from the fact that that's how the VO put it, it's of interest that Lord Justice Oliver and Lord Justice Ackner agreed with it.
My Lord, I'm sure that's of far greater interest to mine. I'm grateful for him to drawing it to my attention. May I move on from Edmondson to the decision of Hayes, which is a decision of the Lands Tribunal. And Hayes is worth the court looking at because it's in a sense, Hayes is, I respectfully suggest, Hayes is the boundary case rather than Iceland, because Hayes is a case where the cooling plant actually isn't, it's actually heating plant and fire protection plant, but the service plant isn't doing something to another piece of equipment. It's actually just doing preservation. So it's a harder case on trade process. And it's not necessary to my argument to say that Hayes has been rightly decided. And it's fair to indicate that both the upper tribunal in this case and the Court of Appeal proceeded on the basis that they didn't get any assistance from the decision of the tribunal in Hayes. But it is an experienced Lands Tribunal member, Mr. Emlyn Jones, and it's also important in the chronology because this is a case that comes very shortly before the Wood report that I do draw attention to and rely on. So this shows at least the way in which this proviso had at that time been understood to work in the upper tribunal. So I'll deal with it shortly. The facts are effectively it's a tea warehouse in Limehouse. I'll take this from MS 476, the head note, if that's acceptable. Thameside 6-storey former tea warehouse at Limehouse used for storage of documents, archives, records, tapes, films and similar small items. And the point of interest for present purposes is how the heating system relates to that exercise and how the fire prevention system relates to that exercise. The heating system we pick up from the decision of Mr. Emlyn Jones, which starts at 477 left-hand column. That's the MS number. Giving his decision, he then describes the hereditament, and then there's a short piece recording the evidence. So may I pick it up at 277, just below letter H on the internal numbers. That's right-hand column of MS 477. The warehouse is used for the storage of important documents, archives, records, data banks, video and automagnetic tapes, films, maps, dry core samples of geological drillings and other small items that can be stored in small containers capable of being readily retrieved at any time. Because of the sensitive nature of some of the materials stored on the premises and at the request of the owners of the materials, part of the ground floor, first floor and second floors are required to be maintained at a temperature of over 70 degrees plus 5 degrees Fahrenheit and with humidity of 55% plus or minus 5%. Parts of the ground floor and first floor are also protected by a special form of firefighting equipment employing the use of Halon gas. The advantage of this method is apparently that it cuts out the fire without causing any damage to the goods stores and is regarded as essential for some of the archive material, particularly film, which is irreplaceable. The dispute in this case turns principally on the question of how far, if at all, the assessment of the hereditament for rating purposes is to take account of the goods lift and the firefighting equipment. Now, we're not concerned with the goods lift. We are concerned with the firefighting equipment, but then it says, as originally put forward, the case for the valuation officer also submitted that the heating plant and the humidifiers were also to be valued as part of the hereditament. And then I emphasise this, but in the light of the evidence called, that's the special regime for looking after the sensitive storage material, on behalf of the appellant, this claim was not proceeded with the exception of the central heating in one of the offices. So concession that that heating arrangement was within the proviso.
So that was the position taken by the valuation office at that time. And I think, as you showed us earlier, it was the prevailing orthodoxy sometime.
Yeah, but my lord, yes. I mean, in a sense, this is a case where the only activity, if I can put it that way, is the creation of an environment. So it's a weaker case than Iceland, or it's a different case than Iceland. Potentially it's a weaker case, I would suggest, than Iceland. But the orthodoxy was the focus is on the particular activity. Here, the particular activity is the storage of sensitive materials. The heating system is deployed for that purpose. I've heard the evidence. I'm satisfied mainly for that purpose. It's out. That's the logic, and as my lord has indicated, it flows.
That was 1986. When was it first suggested by the revenue that was wrong?
These proceedings? This case is cited in the rating manual, which...
But as you showed us.
But it was said it was wrong, and I'll show you why it said it's wrong in just a moment, because when we get onto the fire protection equipment, there's a holding from Mr. Emlyn Jones, but but the reasoning that's impugned in relation to the fire protection isn't recorded in relation to the heating. So the heating is of interest as an agreed position where the argument wasn't even advanced. The fire protection equipment submissions are dealt with very shortly at 478, MS 478, under the heading fire protection equipment. For the valuation officer, Mr. Sainer accepts that there are 3 hurdles to surmount and sets out the various tests. Mr. Sainer, on behalf of the valuation officer's submission, was that although the fire protection equipment protects the materials stored on the premises, its main function is to protect the building which is housing the material, and the storage of that material cannot properly be described as a trade process. In his submissions, these words are intended to apply in cases where some manufacturing operation involves some particular degree of risk, such as the handling of molten metal. Now, there's some echoes of that submission in the line that Mr. Moorshead takes, to be fair, but it was rejected by Mr. Emlyn-Jones in the following way. I cannot accept these submissions. In my judgment, the firefighting equipment, like the heating plant and the dehumidifiers, is on the hereditament primarily to protect the material that is stored there, even if it were to be found that this could only be done by the protection of the building, and therefore that the main use of the that was the main use of the equipment, it would necessarily be included within the schedule because it was there expressly for the purpose of the trade processes being carried on. In my opinion, the trade, insofar as material on this point, was the storage of sensitive materials, and the process was the provision and maintenance of a suitable temperature and environment involving the application in emergency of a non-toxic and harmless gas which had the effect of extinguishing a fire. Now, it's fair to say that Mr. Moorshead criticised in the upper tribunal the concept that he calls in his case scanning around for a trade, scanning around for a process, putting the two together and assuming there's a trade process. Now, there may well be some force in that on orthodox construction principles, that isn't the right approach, but my submission is that this is likely to be the right answer irrespective of that reasoning, because what's happening here, albeit that this is the boundary case, because all that's happening here is the creation of an environment for storage. It's a much less activity-based position. The creation of the environment is the only activity. In my case, there's equipment, non-rateable machinery being deployed. Here it's the service plant that it's said takes the role of the process plant because it's based on an activity. So it's a more marginal case, but if my submissions on ground 1 are right, that the real distinction is actually the particular work of the tenant, the fact that the particular work of the tenant here is the storage of sensitive material is and should be in itself enough. So Hayes may well be rightly decided, even if the precise reasoning of Mr. Emlyn-Jones is open to criticism on the basis Mr. Moorshead advanced, and the upper tribunal in particular found to be well-founded. My submission is it's not necessary for Hayes to be correctly decided for Iceland's appeal to succeed, but it is interesting as being a boundary case where the only activity is the creation of an environment, unlike our case where the activity is an active intervention using equipment on a continuous basis, and it's that which the air handling system mainly supports. So that's Hayes, which is the high point of the proviso as a wide approach. But that high point immediately preceded the Wood report, which I do want to turn to and call attention to various parts of. That's in the authorities bundle at authorities bundle 4, tab 35. Worth looking at the front page, which is MS 1146. To see the status of the document, a report led by a committee chaired by Mr. Derek Wood, consisting of a number of experienced surveyors from the Valuation Office and also private practice. This is the report that feeds into the 1994 regulations, which are the part for our purpose that slightly rejigged the way in which the proviso was expressed. So the most important part of this document, I'd respectfully suggest, is the bit that bears on what they had in mind for that proviso and why they changed it. and I'll go mostly to those, but may I just, it contains a summary of some of the history in a fairly accessible form. It also has a chapter 4, dealing with the position in Scotland, which may be of interest at 1157, that's the MS number. There's a passage that both sides have referred to that I'll just alight upon briefly, which is paragraph 6.6, which is under the heading of valuation hypothesis. And it said at 6.6, which is MS 1163, since rateable values are derived from hypothetical letting valuers base their assessment on rents being paid on the property itself and comparable property in the locality. This practice works well in sectors of commerce and industry where a rental agreement between landlord and tenant is a normal way of providing accommodation, and there is therefore sufficient reliable evidence of the rents paid from which to derive a rental value. Service, plant and machinery which is installed in the bulk classes of property, offices, shops, warehouses and light industrial buildings, and which is essential to its beneficial use, is taken into account in the passing rent. Now that's relied upon as a peg against me. In my submission, it's an uncontroversial observation about the availability of rental evidence in the bulk classes. It's simply an observation about, you would normally expect air conditioning for an office or air conditioning of a warehouse where it is performing service functions, and that's undoubtedly for the benefit of the building itself to be included in the rent.
So that's what we call motive.
Precisely. It's an factual observation about the availability of evidence in relation to motive plot. It doesn't bear on the issues that we have, other than it links in the concept of being essential to the beneficial use of the building, which is the rationale for service plant. But our case is we don't fall within that rationale. We fall within the rationale of process plant, which is normally exempt outside of the schedule.
Yeah, I think from memory, I think Hunslet, they used the contractor's principle. So I mean, if it's not included in the rent of comparable properties, obviously you can't use the comparative principle. So, but if the plant were rateable, you would then be driven to use some other method of assessment.
Which is in fact what happened in this case. They used a contractor's basis, and it produced a fairly high valuation, although it may be said reflecting the fact it was a very sophisticated system. But my lord, yes, it's an uncontroversial comment on the availability of evidence. We then get to 8.7, where having set in historical context, that's MS 1169, 8.7, therefore, like all our predecessors, we accept that the tools of the trade exemption is legitimate up to a point, and there are some items of plant and equipment which are of such a size and nature that out of fairness to other ratepayers, they must be taken into account, i.e. the controversial boundary in class 4. Now, just thinking about that concept of tools in the trade, what are the relevant tools of the trade here? Well, there are integral freezers. They're obviously the tools of Iceland's trade. They shouldn't be rateable. They're not rateable. The issue is, how do you treat cooling plant that bears on the facts as found a main relationship with those? And we'll see how that happens in just a moment. So 8.8 and 8.9 is where they identify the issue that arises as they say, what we have said, if I pick it up at 8.8, what we have said so far relates to plant and machinery which is used for the purpose of a trade or industrial process. There is also the problem of plant and machinery which is introduced for the purpose of providing services for the premises or which forms part of its infrastructure. This type of equipment has never given rise to any difficulty as a matter of principle. And then there's some observations about the letting market and who typically applies it. The difficulty arises in the practical application of the principle, again, as our predecessors have found, because it's extremely unusual in the case of large industrial property to find plant and machinery which is installed exclusively for the purpose of providing general services such as light, heat and ventilation, and is not also closely bound up with the trade process. In the existing regulations to each of the countries of the United Kingdom, it has therefore proved necessary to draw some fairly arbitrary line to indicate the point up to which such plant and equipment can fairly be rated by analogy with commercial hereditaments generally, and beyond which rateability should cease, because at that stage it is impossible in practical terms to disentangle the service from the process function. So I would say that's the straightforward, age-old distinction between process and motive being expressed. We have looked at the boundaries which have been drawn in the past and have redrawn them in order to simplify the task of valuers, assessors and agents to reflect some of the technical changes which have taken place in industry since they were last reviewed. Now, Mr. Moorshead focuses in, or the valuation officer focuses in on the concept of industry. Just for that, before we get to how that's done, to try and have an understanding of the range of concepts that are understood by industry as used there, and it's used elsewhere along with trade, it's worth just glancing at MS 1220, which is Appendix L to the Wood Report, where we see what's in mind apparently on the face of this document under the rubric of industry. We've got petrochemical at 120, iron and steel works, shipyard, and then over the page cement works, and then over the page, materially for my purposes, retail distribution. There is no change of state taking place in a retail distribution facility. And the refrigeration plant in such a facility is process plant. See the no on the current rateability situation and the no on the recommended rateability section. Then we've got high-tech industry, and you'll see there's some discussion of computer suites about to emerge in a few moments. So that the question is, back at MS 1170, the question is in the bottom, the last line there, how do we draw this line? And they then indicate that there needs to be the line at 810 subparagraph 5, that in the case of plant and machinery which performs both a service and a process function, sensible lines have to be drawn which indicate exactly how much falls to be rated and how much does not. So it's to that sensible lines that we are concerned with. The proviso is about drawing the sensible lines. They go on to expressly discuss it in section 9. And we get to section 9, which starts on MS 1173. The court will note the heading power, which I take as read. I've already alluded to 9.3, which formulates the general purpose of the power provisions together with the approach to that. But we're concerned with other services, which starts at 9.11. They set the scene in 9.11. At 9.12, they start by referring to the legislation, and then there's this observation. It appears to us that the underlying purpose of this lengthy definition is to ensure that service plant or machinery, other than plant and machinery, which is mainly or exclusively provides services for manufacturing operations or trade processes, is rated. The definition is not, however, free from ambiguity, and it has opened the door to disputes about when plants should be treated as falling within Class B. An example of the problems created is the treatment of air conditioning plants. This may have been installed to facilitate a particular process, for instance, computer suites or clean rooms, or to enhance the working conditions of employees, but it's impossible to distinguish between these purposes. In other words, on this boundary, you encounter air conditioning, which is doing two things. It's serving a computer suite or a clean room. In other words, keeping the computers from getting too hot, cooling them down for the purpose of them working properly. That, in the mind of Wood, is a trade process. He's obviously not contemplating industrial transformative when he gives that example. What he's contemplating, in a word, is plant that falls outside of the schedule by virtue of what becomes Regulation 2B. That is the terminology of process plants.
Does he refer anywhere to the Hayes case?
I'm not sure if it's discussed earlier in the report. Mr. Moorshead says it isn't, and that may be right. it does.
But I mean, from what you said earlier, this would have been the orthodoxy at the time.
There was an unchallenged decision of the Lands Tribunal that's consistent with this analysis, which is why I showed the court this in a chronological order, because one sees an entrenched...
Yeah, it doesn't mean it was right, but at the time, there was no... One can understand why the Wood Committee had treated that as an orthodoxy.
But yes, and the Wood Committee is then advising on what the legislative change should be on that express basis, and the regulations with which we are concerned are one removed from the 1994 regulations, which on their face say they give effect to the Wood Committee. So what the Wood Committee understands this proviso to do is very important in terms of understanding the mischief to which this proviso is directed in the existing regulations. So, my Lord, and then my Lords and Lady, then there's reference to Scotland, and that my Lord Reid, this hopefully is an answer in part to a question raised earlier in the discussion. In Scotland, the same result is achieved by the use of less ambiguous language, and there's a reference there to Article 3 of the 1983 order, which is discussed in the Beepy and Lothian case that I refer to in my case, and I'll just mention in just a moment. However, the problem of apportionment between different service functions remains. And then this is the part where they go in to look at the options with their eyes open. We have considered whether the current definition should be amended or dropped altogether. For example, we have discussed whether it might be preferable to exclude from rateability only that service plant which solely supports a process function. In other words, we've thought about really tightening this test. However, to treat plant as process plant only if it was wholly used for process purposes would increase the rateability of this type of plant and machinery. Such plant is rarely met in practice. As an alternative, we have considered whether it would be possible to apportion the value of the plant between Class 1B, which is now Class 2, and Class 4, reflecting the relative, so for both of those classes, but we're only concerned with Class 1B, which is Class 2, reflecting the relative use for services and process activities. Pausing there, that's the answer to the fairness argument. Well, you should be paying 40% for your general air conditioning and have a 60% discount for your process. Possibility expressly contemplated by Wood, but rejected for the words that follows. This would run contrary to our desire for cost-effective valuation effort and would create new opportunities for dispute. So it's all or nothing. It's a bright line. If you're on the right side of it, you're a winner. That's the legislative policy. It couldn't be more clearly that that's what the Mainley test is designed to do. And the unfairness point taken against us in paragraph 123 of the respondent's case is manifestly inconsistent with the express logic of the Wood Committee which led to the regulations. We therefore concluded that notwithstanding the difficulties which have been encountered in deciding the degree to which plant is used for process purposes, the law as we understand it in both England and Wales should remain unaltered, but the draftsmanship should be improved to eliminate the difficulties inherent in the English regulations, and that becomes the way in which the mainly or exclusively formulation is. First of all, in the 1994 regulations, carried through without amendment to the 2000 regulations. So that's the critical passage. I would respectfully say 912 on the ambit of the proviso, absolutely clearly not transformative industrial, includes computers. Why? The explanation I offer is because it's including process plant, knowing full well process plant occurs in a whole myriad of hereditaments, laundrettes, for example, computer suites, and dare one say, retail shops that use cabinets that perform a process function. That's what they did, and 9.14 is when they thought about the options but preferred the mainly or exclusively test, which does put a judgment, a difficult factual judgment on the expert tribunal system, but that is not an unusual position to place them in. They are well equipped for dealing with that, and it is orthodox that they have to make calls about how one characterises a use, understanding the factual context and exercising judgment, and hearing contentious evidence if the allocation to one side or other of the line in difficult cases requires that. That's all uncontroversial features of the way in which rating legislation, tax legislation, many other social security legislation works in a great many cases. That's the Wood report. Then one last English authority, which is the Leader case. So lest it be said that somehow the Wood Committee were taking their eye off the ball when they were thinking about computer suites, as within the ambit of this, we've got the decision of the upper tribunal in Leader Properties, which the court will find at volume A2, tab 23, MS 693. I'll deal with this very shortly, if I may, but the issue in this case, so it's MS 693, the issue in this case was the deletion proposal in respect to the first generation computer centre on the basis the ratepayer said it was incapable of beneficial occupation. Now, whether that was well-founded or not depended in part upon the view one took of the status of the plant there, which was mainframe computers and an air handling system that served it that had been partly removed and was partly obsolete. If the court goes to MS 697, see it's a decision of Mr. George Bartlett. I ought to draw attention to the representative of the valuation officer in this case.
The best tradition is that you're going to argue against whatever you...
Well, fortunately in this case, my submissions are entirely aligned with the analysis in Leader, but advance on the other side of the debate in this case. But the proposal is recorded at 169 of the decision. So the ratepayer contends the heritage should be deleted from the list on the grounds that it's incapable of beneficial occupation. Then there was an issue about valuation, which actually was held to be out with the bounds of the proposal. So the only question, in fact, was deletion on the basis of incapable of beneficial occupation. The agreed facts are recorded at 170 of internal 170, that's MS 698 at paragraphs 2 and 3. So first generation purpose-built computer centre, principal buildings, paragraph 3, large data processing hall. And then can I pick it up halfway through paragraph 3? The main computer hall has a sophisticated air handling system to provide the temperature and humidity control necessary for process purposes. 5 large air handling plant fan chambers deliver conditioned air to the main computer hall and ancillary tape storage and job control rooms via high-level distribution ductwork within the false ceiling void and through the perforated ceiling system. I'm not sure the detail matters, but that's the nature of it. Paragraph 6, former Ministry of Defence, occupation vacated and then occupied by a company known as Capgemini in paragraph 8. 11, which is the critical part for, just 10, para 10, the appeal property was a first-generation computer data processing centre. Nationally, there are several examples of purpose-built and converted computer centres of similar age to or older than the appeal property that are still operable on the material day, and some of those were identified. 11 is critical for present purposes. It was agreed that certain elements of the demised property, in particular items of plant, not made rateable under the 2000 regulations, do not form part of the rateable hereditament. Mainframe computers are not listed in the regulations and are to be disregarded for assessment purposes. It's also agreed that the air handling and cooling plant and machinery provided an automatic and space temperature and humidity controlled environment for the benefit of the mainframe computers are not rateable. The presence of these items of plant is to be disregarded, and also is the cost of any remedial works to them. So that's the agreed position of the valuation officer and the ratepayer. The ratepayer actually had a financial interest in arguing the contrary, because if you took account of this obsolete material, that would support the approach. But it's clear that they didn't take that point, as is clear from paragraph 29 of the decision where the ratepayer's approach is set out. So they say much of the specialised, so midway through 29, much of the specialised cooling and air conditioning was either removed or non-functional, although since most of this equipment was non-rateable, it fell to be ignored under the rateable hypothesis. And the valuation officer at 32 just asked the court to note evidence of the valuation tribunal given by a Mr. Howells, who is said to have had 37 years of rating and valuation experience, and since 1996, so for 13 years, had specialised and taken a lead role in the valuation of specialist class of properties, including computer centres. He dealt personally with the assessment of all computer centre data processing properties throughout Wales and South West England for the preceding 3 rating lists. And his position in relation to the approach to the plant is as recorded in paragraph 34 of the decision. Mainframe computers were costly items of plant, but since they were not named, this is over the page at the top of MS 706, since they were not named items under the plant and machinery regulations, they were to be left out of account in valuing the hereditament. Similarly, the air handling and cooling plant was not rateable, and although the cost of replacing this would have been considerable, this was not a matter that could affect the assessment. So it would have served the ratepayers' purposes to argue that you could take it into account. They didn't do so. Very experienced President of the Lands Tribunal, Mr. Bartlett, deals with the point shortly and by consent, effectively recording for present purposes in paragraph 36 at the foot of MS 706, the provisions of the 2000 regulations, the acceptance and the position in relation to their application in paragraph 37. So sets them out and says, although at the date of the proposal much of the specialised cooling and air conditioning was either removed or non-functional, Mr. Messenger accepted that since most of it was non-rateable, it fell to be ignored in the hypothesis, and he proceeds on that basis. So the position in relation to computers, the heritage of it is pre-existing practice, commented on by Wood, commented on in Leader, and makes its way and stays in the rating manual. All of it contrary to the thesis that's been advanced in this.
Session you were making on behalf of the valuation officer is consistent with what you're now saying.
It is.
I see Mr. Morshead in paragraph 117, as I understand his comment on Leader, he doesn't dispute that it was in line with the practice as it was then, and really says that's not binding on us, and of course that's right.
Well, perhaps I could wait to reply to see how Mr. Morshead says, so what, that, I assume he says, so what, that's wrong in law.
Yes, no, I'm just saying that it seems to be common ground that the valuation practice was consistent. Yes. There's both sides, and it's only, as you said, it's only read in this case that there's been a change of position.
I think that's an entirely fair summary of where matters have got
to. It also helps to explain, as you said, why the valuation tribunal in this case took the view they did.
Yes, and I obviously, were your lordship and your ladyship to be of the view that Mr. Morshead is right. I don't suggest that this long entrenched practice stands as a legal obstacle. But what I do say is that it's a useful barometer with which to test the good sense and practicality of the competing submissions in this case.
Unless there's evidence that it caused lots of problems during its period, then that obviously removes one possible objection to us taking.
Yeah. It would appear that the mainly or exclusively threshold put in by Wood with its eyes open was working okay in practice. And of course the boundaries are tested in cases such as this, but that's inevitable. So those are all the English authorities. I want to draw together my submissions in just a few moments, but may I just spend just a couple of moments, perhaps by reference to my written case, just drawing attention to the position in Scotland, which is paragraph 77D of our written argument, which is in the core volume at MS 74. And I think the points that we seek to take from that, I accept it's a slightly different case, but the the issue of interest in that decision is the approach to the phrase industrial or trade process. It's it's dealing with a pipeline, and there's a test about whether or not the pipeline is within the curtilage of a facility, which fails on the facts. But the whole argument proceeds on the basis that the marine terminal which it served, whose purpose was to load refined oil onto ships for onward transportation, and receive oil, but not for any changes of state to be made, was premises used in an industrial or trade process. So the relevant part of the finding is page 459 of the decision of Lord Ross, and the facts are described at page MS 471.
I appeared for the assessor before the committee. I don't recollect there being any issue about whether it was a trade process or not.
It appears to have proceeded by agreement, which is a strong indication, given what Wood says about the consistency of the basic approach in Scotland and England, that this idea of transition being a prerequisite or an essential feature of the trade process is not something that has any heritage. There's no footprints of it anywhere.
It's a bit like materials handling, isn't it? Bit like materials handling. You're moving the oil around.
Yes. Yes. I mean, this was the tap at the end of North Sea oil.
Yes.
Effectively.
Yeah, but nothing. It moves through it, but it doesn't. It doesn't change its state or anything of that nature. So,
sorry, we don't have, do we? In the Wood report, seems to regarded in paragraph 913 the relevant provisions in Scotland
yes,
as being less ambiguous. They were not the ones in the Grangeland case, but we have those.
They're in an annex to
Yes,
the
they're in an annex
report.
to Wood.
they are annexed to Wood.
Oh, they are in the annex of Wood. Okay, thank you.
May I just try and?
Don't worry.
Well, I don't think you need to go to the...
Yes, they're there. I can find them. Thank you.
Now, you were going to draw your...
Yes, I'll draw my threads together. If that, in the 20 minutes or so that I
Oh, well, you won't need 20 minutes to draw your threads together.
I have left. So the encapsulation of our case, as I hope I've made clear as we go along, is that the background material show that the focus of the proviso is to differentiate service plant, properly so called, which is essential to the hereditament, from plant which serves the tenant's particular activity, where the former, i.e. the service plant, is rateable, and the latter, i.e. plant serving the tenant's particular activity, is non-rateable. Now, the tenant's particular activity is likely to be undertaken utilising equipment which is itself non-rateable plant. And the examples I've given already, the factory in Townley Mill, the computers in the Wood Report example and Leader property, the refrigeration machines in a retail distribution centre, as mentioned in Appendix L of the Wood Report, or the integral refrigeration machines in Iceland store. So when the breadth of plant which is non-rateable outside the schedule is taken into account, this approach to the proviso, in other words, a wider approach, giving the words trade process a meaning that doesn't limit them to changes of transition and quasi-industrial contexts, makes sense and makes the intended distinction work. I would suggest it was no part of the statutory intention to treat an adjunct to process plant as if it were service plant. The statutory intention is to classify service plant, properly so called, that's essential to the hereditament. And the proviso really works, I would respectfully say, as an accessory to non-rateable plants. You've got the non-rateable plants, and if the position is that the air handling unit in our case is mainly serving the non-rateable plant, then the scheme makes sense and works for its intended purpose to treat it as an accessory to the non-rateable process plant, rather than to treat it on the fictitious basis that it's actually serving the hereditament itself when it doesn't fall within the intended purpose of such a provision. And we say there's a golden consistent thread running through all the materials that supports that. When the first conceptual distinction between process and motive plant was articulated in the short report, paragraph 15, that's the basis on which the House of Lords proceeded in Townley Mill. It's consistent with the express words used by Neville Chamberlain, and the survey of the rating case law that I've taken my lords and lady through shortly this morning all suggests that more expansive and inclusive approach to this phrase, as does the clear discussion of the computer suites in the Wood report. The attack on it in terms of fairness to the ratepayers in Mr. Moorehead's paragraph 123 of his case is explicitly answered by the Wood Committee in 914 and 915. So I say, in short, there's no policy reason at all and no reason of language why trade process should be treated to a narrow definition, and in deciding that, the Court of Appeal didn't have in mind a proper understanding of the function of that proviso within this statutory scheme.
I can see how you get from the service plant, as it were, to the adjunct to the service plant. That's providing you've got a process. And the process in this case is?
Well, I say the process is the deployment of the cabinets as a piece of equipment which is to maintain food in a refrigerated state. In other words, it's an intervention to achieve preservation, but an active intervention to achieve a status quo. But the critical part of it is an activity and an end. I say refrigeration is a process. It may be that a safe, if I'm right in my ground one, I say it's the particular activity of the tenant. So it's frozen, keeping stuff frozen in the way we choose is enough on my ground one. If that's too wide, then the fact that we are using non-rateable equipment in the form of the freezers, which are intervening all of the time to achieve a particular end, which is the tenant's purpose of maintaining the food in its refrigerated and frozen condition, that, I say, is undoubtedly a process on any basis of the word. And the reason I say it's an adjunct to the non-rateable process plant is because on any sensible analysis, those freezers are non-rateable plant because 2B takes them outside the scheme.
Yeah. So is all storage a process?
Well, that's I say that the real boundary of interest is the position in Hayes, where the only activity is the creation through the putative service plant of creating conditions for storage. That is a different and harder case than my case. So it's in no way a necessary part of my case to succeed, and Hayes being rightly decided. There is a distinction where if one focuses on the deployment of equipment, which is itself non-process plant, you can make sense of all of the authorities, perhaps with a caveat about Hayes, and my situation, I respectfully say, falls comfortably within that. But I say Hayes is the difficult case, but on my ground one, Hayes ought to succeed because of the particular storage facility of sensitive is a matter that's particular to the tenant rather than essential to the hereditament. So I say Hayes is rightly decided on my ground one, but I don't need to go that far.
Can I ask if you look at class 2, which is on MS 200, there's a difference in it's in volume 1 tab 2, I think. You'll see class 2 begins by referring to plant and machinery specified in table 2, which is used or intended to be used in connection with services to a hereditament. And services is defined at the end of that provision to mean, amongst other things, cooling. Okay, so plant and machinery which is used or intended to be used in connection with cooling services to the hereditament or part of it. Okay, so that's fine. Other than any such plant or machinery which is used or intended to be used in connection with services mainly or exclusively as part of manufacturing operations or trade processes. So we're again talking about plant or machinery used or intended to be used in connection with cooling, and the cooling has to be mainly or exclusively as part of a trade process. And I suppose you're having to say that as part of the trade, assuming the trade process is maintaining the chickens in a frozen condition, but this is the air conditioning of the shop, in order to address the problem of heat arising from the freezer cabinets, is part of that process.
Yes. Well, I'd say that's I say that's a very small step on the findings of the tribunal, because you'll recall at the beginning the discussion that you couldn't leave the refrigerations working without the system handling. The system had to work all of the time. Such is the intensity of the heat load that's thrown out by these refrigerating systems that operate all the time, that the air handling plant needs to be on all the time, whether occupied or not.
Yes, yes.
And therefore it is an essential part of the process of keeping the food cold. Because effectively the cabinet, it's not safe to leave the cabinets without them.
Yeah. Well, it's addressing a problem that arises from the trade process.
Yes.
I'm wondering if it's properly described as part of the process.
Well, my respectful submission is that the process is the maintaining the food refrigerated. Factually, it's done by the cabinets. Factually, the cabinets can't function without the air handling system.
Well, they could, couldn't they? Is it not that the shop would become uncomfortably warm?
No, as the evidence set out, they were required in order
I
to
beg your
prevent
pardon.
breakdowns.
Fine.
That was thoroughly argued. It was the case against me below
Yes.
on the facts was it was comfort cooling.
Oh, thank you. That deals with it then. Thank you very much.
I mean, that was why it took so long in the upper tribunal, because that sort of debate was hammered out, and the findings are as recorded. But I think the factual answer to my Lord Aubrey's question is, on the findings, it needed to operate in order for the cabinets to do their job.
Yes, thank you very much.
Sorry.
Yes.
I should say one last word on ground 2 and then deal in the 10 minutes I'll have left with a couple of observations in relation to Mr. Moorehead's argument, if I may, in my allotted time. So on ground 2, it's a very, very short point, but I say even if the analysis of the purpose of this proviso, that's the subject matter of ground 1, is not persuasive to my lords and lady, then I say that on the straightforward use of ordinary language, there is no reason why refrigeration is not an activity that's capable of being decided as a trade process. You've seen the union storage case where it was proceeded on the basis that it was. We've referred in our case at paragraph 78 to a couple of instances from the capital tax context where the courts have wrestled in a different statutory scheme with the extent to which transformation was a necessary part of a process and have tended against that being an essential prerequisite, the real character being the continuous intervention, which here is plainly taking place. So I say that even absent the purposive approach to the statute, there's a straightforward ordinary meaning point that we are a trade process. The cabinets are part of that trade process and they are on the facts supported by the air handling unit. Then in the short time I have available, in relation to Mr. Moorehead's approach, I'll try and make 6 short observations. First, I say that his approach isn't supported by the background material he relies on. That does show agitation from industry. It does show a concession to industry based upon a better situation being created in Kirkby, but that is in no way a sufficient explanation of the change that took place, which was effectively a codification, or a sufficient explanation of the basis of the proviso, which in effect was a way of mediating between plant that was understood to be outside of the scheme by virtue of what has now been Regulation 2B and the plant that's properly serviced plant, so properly called. I invite the court to reject his construction arguments. In my submission, they don't work from the deployment of the word or between the concept of manufacturing, operation or trade process. Rather, they serve to take away and collapse the independent meaning of trade process. And that is a position that is not, in fact, supported, I would respectfully say, by a fair reading of the cases that he draws attention to in paragraph 86 of his submissions, which are, in any case, a very long way from the particular legislation with which this court is concerned, which is really the proper basis for deciding how these words should be deployed. The word industry, which is implied into the scheme under Mr. Moorehead's analysis, is a word that was known to Parliament in 1925. And in fact, although the extract hasn't quite made it into the court materials, there was a note in Schedule 2 to the 1925 Act where something turned on the use of industrial purposes. So it is a word that's used in one instance in the Act. And I can hand that in just before we rise, if that's of use. I don't think I need to make any submissions in relation to it, but I do draw attention to it, and I've drawn it to Mr. Moorehead's attention. The other point is that actually there was a parliamentary strategy dealing with industrial derating that came 3 years later, starting in 1928, and which was in place until 1963, which did give a direct concession to industry through separate legislation, born, as I understand it, in the immediate run-up to the Great Depression, where there was an attempt to make ourselves more competitive in broad trading terms. But that's a completely separate piece of legislation. So the industrial thesis doesn't work on the words of the Act and doesn't work on their ordinary meaning. It also would drive a wedge between the position in England and Scotland, given that the Scottish legislation talks about industrial or trade process, so plainly is not proceeding on the basis that trade process means something akin to industry. So there's no linguistic or policy basis for the restrictive approach he advances. And I do say it doesn't take account of the broad point of quite how much rateable plant is non-rateable, quite how much plant and machinery is non-rateable by virtue of being outside the schedule, which is the thesis that I've developed in detail this morning. So his purposive approach, my third point is his purposive approach doesn't make any sense. The fourth point is, as in particular Lord Carnworth has observed in the course of argument, it is flatly contrary to not only the examples but the long history, and there's no indication that the established approach wasn't working, and every indication that a broader approach than the industrial transformative approach that Mr. Moorehead advances is the right approach. Fifthly, it doesn't fit with the general canon of construction that generally statutes are always speaking. Why should the ambit of this proviso be crystallised in 1925 as opposed to being approached in a more purposive way that's capable of being fulfilled as particular trade activity changes? And that's particularly right because he tries to crystallise it based on his analysis of Short in 1925, when it was in fact expressly considered by Wood on a wider basis before it was reenacted in 1994, before it became 2000, on a basis that expressly didn't restrict it in that way and which flowed from a load of cases in the specialist tribunal that had taken a wider approach and weren't disowned in the Wood report. In fact, the Wood report is entirely consistent with them. And sixthly, and finally, as we say in our written case, the emphasis on transformative quality just produces an arbitrary line that's remote from any justification. The freezing chicken example, which is there as the boundary on the Court of Appeal's analysis, shows how arbitrary this is in operation, as is the idea of an inquiry into what's happening on the computer screen of the computer plant that's supported by the air handling plant. By contrast, I'd respect, and as a point I've already made, no reason why preservation can't simply be added to the list of features of a trade process that are encapsulated in paragraph 41 of the Chancellor's judgment. Its omission is an anomaly rather than a product of a coherent logical reasoning process, I do submit. And by contrast, I'd respectfully submit, and final point I make, that our approach is actually seeking to give effect to the essential division and the role of this proviso in the statutory scheme, and it's consistent with the approach that has worked perfectly well before the approach that's before you on the respondent's side of the argument was advanced for the first time in the upper tribunal in these proceedings.
Good. Thank
Can I just ask you one thing, not to say now, and it may be in the papers. I'd like confirmation that the 2000 Scottish valuation provisions are, for material purposes, the same as in England. I was trying to look at them. Actually, I think they probably are.
We'll endeavour to look at that.
I mean, it makes sense because they were revised following.
Unless I can assist your lordships or your...
Yeah, thank you very much indeed. Mr. Wilcox?
Nothing from me, my lord.
Mr. Morset?
Lord, like Mr. Kalinsky, if I may, I'll take the written case as read. Nothing I have heard this morning leads me to wish to withdraw any submission there made, so I do take it as read. May I start with what I'm going to call 3 general submissions, which will be aimed at the following targets. First, isolating one key insight made by the Lands Tribunal, which will be of assistance to your lordships. Secondly, demonstrating the importance of context, physical context, as well as linguistic context. And thirdly, indicating the extent to which Iceland's approach departs from the statutory language. Those will be my 3 introductory submissions. I will then, if I may, enter in slightly more detail on the authorities relating to statutory interpretation, because a lot of material has been looked at to bene esse without much reflection on the principles which control its admissibility, and even if it's admissible, what it's useful for, what weight one can give it. I will then examine the historical material to see what that actually shows us. I may then have to say a few words about rebus, although I note Mr. Kalinsky did not orally make representations about the rebus principle, which may shorten any submissions I make about that. And finally, I will have to respond on the authorities. So if that's an acceptable roadmap, my lord, I'm happy to start straight away with the first of my general submissions, or to abide the intervention of lunch, as suits your lordships and your ladyship.
Well, it's a matter of you. You have 3 minutes left if you prefer.
Well, then may I start by introducing the insight of the Lands Tribunal, which I say is of critical importance by reference to its decision in the core bundle, starting at page 143.
In the upper tribunal.
Forgive me, yes, 143 of the upper tribunal's decision. I've got 5 paragraphs to show your lordships. I think I can do it in time before lunch. But paragraph 20, remind your lordships of what's said in the 3rd line down. Where a large number of integral cabinets is present in a confined space, it is necessary to provide an air handling system with a correspondingly large cooling capacity. That's the first paragraph for establishing the context for this insight. At paragraph 29, can I call your attention to the last sentence? It's clear that without the integral cabinets, the air handling system installed in the store would not be required, and a very much smaller system would be sufficient. I ask you then to look at paragraph 63, which is on page 151.
Sorry, I beg your pardon, which number?
63.
Thank you very much.
MS 151.
Yes, thank you.
Describing what is there calls the essence of the 2000 regulations. Plant and machinery within these very broad classifications is rateable. To that general rule, there are limited exceptions, the most important of which, your lordships can see what's said there. But in the last 4 lines, it was not suggested that all plant and machinery installed in a retail store for heating, cooling, lighting, the supply of water and protection from fire or theft can be regarded as being used in connection with trade process simply by reason of its location in a hereditament from which trading takes place. And then in paragraph 65, that is the context for the insight that appears in what follows, my lords. We think there's force in Mr. Morset's submission the common defining characteristic of manufacturing operations and trade processes, and there's reference to transition. But they acknowledge that while there may be exceptions, we don't consider that the display or storage of goods in itself could ordinarily be said to involve any trade process. nor do we consider that the creation of an environment conducive to the display or storage of goods, at least in the context of a retail warehouse, is properly regarded as involving a trade process. The fact that the environment appropriate to the storage and display of the goods of a particular retailer requires more substantial or powerful equipment than is normally found in retail premises does not create a relevant distinction, nor does the fact that the equipment in which the goods are stored and displayed depends for its efficient operation on the maintenance of a particular environment give rise to such a distinction. I can then go to paragraph 66. All retail warehouses require heating, cooling and ventilation to a greater or lesser extent. We don't consider that the plant and machinery installed to provide those services can properly be regarded as being used or intended to be used as part of manufacturing operations or trade process. We appreciate that the scale of Iceland's particular air handling system is dictated by the presence in its store of substantial numbers of integral cabinets, each of which creates heat, and which collectively are essential to Iceland's preferred style of trading. A serious malfunction of the air handling system would therefore put its stock at risk. That feature distinguishes Iceland's air handling needs from those of other retailers, but we do not regard that difference as critical. Although the particular needs of Iceland create a greater need for those services than the norm, we don't agree that they make its air handling system an exception to the general rule that such plant and machinery is to be assumed to be part of the hereditament and therefore to be rateable. The key insight of the tribunal in those passages is that Iceland's air handling system responds not to anything you can call a trade process or manufacturing operation, but to the scale of what Iceland does, which is not a manufacturing operation or trade process. And after the luncheon adjournment, I'll return, if I may, with some examples which make this proposition good.
Thank you very much indeed. We'll sit again at 2 o'clock.